It's my honor to welcome our beloved chairman, sir, Dr. Ashoka Raju Konduru, Siddhartha Group of Institutions in absentia for this program. With the same privilege, I would like to welcome Principal Siddhartha Institute of Science and Technology, Dr. M. Janardhan Raju Garu, for this online IPR awareness program. I would like to welcome today program resource person, Dr. Bharat N. Suryavamsi, Additional Controller of Patent and Design, RGNIIPM Nagpur. Last but not least, to welcome you all, participants of various institutions all over India. I request to convener ma'am to continue the addressing of this program. I am requesting to convener Dr. Savitesh Madhulika Sharma ma'am to address the about program today, online awareness program.
Thank you, Dr. Gangaya Yadav, sir. Good morning, one and all, and warm welcome to all dignitaries, eminent persons, faculty, research scholars, students, and participants all across the country. I'm Dr. Savitesh Madhulika Sharma, President, Institutions Innovation Council of Siddhartha Institute of Science and Technology, Puttur. It is my great pleasure to be here on virtual portal today on the occasion of one-day online IPR awareness program on intellectual property rights, patents and design process, organizing in association with Rajiv Gandhi National Institute of Intellectual Property Management, Nagpur, under National Intellectual Property Awareness Mission. So I welcome Dr. Bharat N. Suryavamsi, sir, Assistant Controller of Patents and Design, and it is our honor and pleasure to have you for the series of intellectual property program. On behalf of Siddhartha Institute of Science and Technology, Puttur, and its management, also on behalf of Institutions Innovation Council, established under Ministry of Education, Government of India, to promote the innovation ecosystem in the higher education institutions. Let me brief you about our IIC. As you all know that government is putting efforts to systematically foster the culture of innovation amongst all higher education institutions. In view of this, Ministry of Education envisioned creation of Institution Innovation Council, IIC, across selected higher education institutions. Our institution is committed to actively raising the quality of students and faculties by systematically building culture of innovation and entrepreneurship and necessary ecosystem. The prime mandate of our IIC is to encourage, inspire, and nurture young students by supporting them to work on new ideas while they are in formative years. We are conducting various innovation, entrepreneurship, and IPR related activities prescribed by Central Ministry of Education in time-bounded fashion. We are organizing hackathons, idea competitions, mini challenges, etc., with the involvement of industries. I'm very happy to share that this year we achieved 3-star rating out of 5-star. Intellectual property helped institutions to improve their ranking, establish an innovation ecosystem, incubate knowledge-based startups, earn additional revenue, and measure research activities. As you know that ranking and accreditation schemes in India like NIRF, ARIA, NAC, UGC, and AICT are giving weightage to innovation, IPR, and startup promotion. Now it is desirable to set up IP centers at universities and institutions. According to NIRF methodology for engineering institutions allocated 10% weightage to IPR, NAC allocates 2.6% weightage, ARIA allocates huge weightage to IPR. According to ARIA, IPR carries 40% weightage. Both the UGC and All India Council for Technical Education, AICT, recommends changes to the curriculum with a focus on IPR education in technical institutes. Every stakeholder in an institution, be it the administrator, the professors, the researcher, or the students, now need to know the basics of intellectual property and learn how to identify, protect, manage, and commercialize them. Our goal of today's program is to spread awareness about the intellectual property rights. With this, I am thankful to management of Rajiv Gandhi National Institute of Intellectual Property Management, Nagpur, for accepting our request regarding support for conducting this one-day online IP awareness program. Also, I would like to thank Dr. Bharat Suryavanshi sir for accepting our invitation. Also, I would like to thank our Chairman Dr. Ashok Raju Garu, Principal Sir Dr. M. Janardhan Raju Garu for granting permission and providing necessary facilities to conduct this event. I am thankful to our Head of the Department of ECE, Dr. V. Saroja Madam, EEE HOD Dr. Challa Babu Sir, CSC HOD Dr. M.A. Manivasagam Sir, Civil Department HOD Dr. Srinivasan Sir, Mechanical Department HOD Dr. D. Sudhakar Rao Sir, Basic Sciences and Humanities HOD Dr. K.K. Srimitra Sir, our faculty members of all departments and organizing team, especially Dr. Gangaya Yadav Sir, for supporting us in organizing this online program. Now I am hand over the session to our Principal Sir to say few words. Thank you. Sir, Principal Sir, are you there?
So good morning to everyone. Thank you, madam. So respected chairman, sir, Dr. Kundur Ashok Raju, sir, and respected department HODs and IIC coordinators, members, and all the faculty members and student friends. Good morning to everyone. So I thanks to IIC team for arranging a very good session for all the faculty and students on IPR. So because the future is innovations. So once we go for innovation, everybody should aware of IPR, intellectual property rights also. Thanks for the RGNII Property Management Nagpur. And I also special thanks to Dr. Bharat sir. So thank you so much, sir, and for spending your valuable time with us. Thank you, madam. You can start the session. I think it's already delayed 5 minutes. Hope this program will success.
Thank you very much, sir.
Thank you, madam.
Welcome, sir. Okay, let me give you a brief introduction of today's speaker, Dr. Bharat and Suryavanshi sir. Dr. Bharat and Suryavanshi sir is currently working as Assistant Controller, Patent and Design, Rajiv Gandhi National Institute of Intellectual Property Management, Nagpur. He completed his MSc in Biotechnology and MPhil from Gulbarga University, Karnataka. He also did Doctor of Philosophy from Swami Raman and Tirth Marathwala University, Nanded, Maharashtra, on the topic of bioefficacy and phytochemical studies on mediciner plants of Kinwat and Mahur Forest of Nanded district. He joined the Patent Office in July 2003 as Examiner of Patents and Design Group in Patent Office, Mumbai. He was promoted as Assistant Controller of Patents and Design in December 2012. He presented and published various research papers in reputed journals and conferences. He attended many trainings in India, also got training in Japan. He is well known for his landmark decision on Pfizer patent application for arthritis drug in 2015. He delivered number of lectures in IPR programs in collaboration with colleges, universities, companies, Biotech Consortium India Limited on different topics. He is actively supporting colleges, universities with his expertise in IPR area. With this brief introduction, I would like to request Dr. Bharat sir to start the session. Thank you, sir.
Good morning to all. I also welcome you all for the IPR session. As you are engineering college, you might have filed many patents, designs, and different technologies. Even though I'll throw some lights by sharing my slides. Are you able to see my slides? Anyone, please? Hello?
Yes, sir, it is visible.
Slides are moving?
Yes, it is visible, sir.
Yeah. First of all, I introduce where I'm working. I'm working under the Ministry of Commerce and Industry, Department for Promotion of Industry and Internet Trade. Our office is called as Office of the Control General of Patents, Designs, Trademarks, and Geographical Indications. We are having 4 offices at Kolkata, New Delhi, Mumbai, and Chennai. We are having PIS, that is Patent Information System. Now it is called as Rajiv Gandhi National Institute of Intellectual Property Management, located at Nagpur. We are having trademark offices in addition to 4. One is at Ahmedabad. We are having geographical indication office at Chennai. This is a pictorial view of our offices: Mumbai, Delhi, Chennai, and Kolkata. If you want physically, you are supposed to visit this office and you can file, or you can send by post also. This is our training center, as I told you, RG and IPM, wherein we give physical trainings to all professors, students, lawyers, company managers, scientists, and all the fellows who comes to know what is intellectual property of India and the law. The foreigners like WIPO schools or WIPO summer school programs and BRICS programs. Many we are conducting every year. Because of COVID, all the programs we are doing online. This is our website, wherein if you go to www.ipindia.go.in, you can get all details about the different IPs. Again, this is an awareness program, so that I cannot go in more detail, but we are conducting every month 1 or 2 programs that is in detail. Therefore, we are giving updates on our website as well as on social media like Twitter and Facebook account. If you want to learn more about that, you can join to the different social media and come to know the programs, and you can fill the fees and you can join those programs. Let us see what is intellectual property. By seeing my slides, you might have thinking something which is originating from mind, that is product of mind, is called intellectual property. Yes, how it arises during discussion in the classroom, or if you are teaching on some topics and somebody raises question on some technology, then you are giving solution for that in the form of technology, that may product, process. Therefore, intellectual property means which arises from human intellect, or we can say product of human creations. For example, in 2019, we heard about the coronavirus. At that time, we are not having any treatment method nor vaccine for that. The scientists all over the world started to do the research. In the middle of 2020, they got the solution for that in the form of vaccine, that is Covaxin, Covishield, Sputnik. What is this? It's an intellectual property in the form of product. It is human has thought on that problem. They did research. Therefore, it's an human creation. Therefore, intellectual property means it's a product of human mind. As you are a engineering people, you know solar energy is a renewable source of energy. Somebody develops a device which converts solar energy into an electrical energy, that's an invention. Or somebody who is a mechanical engineer can develop a vehicle which run on hydrogen fuel, that's an technology, that's an invention. The process of production of biodiesel, because one or other day other diesels or petrol may exist, therefore it's an invention. Or if earlier, if you think of that, we are having pollution lot of. Somebody is developing biological treatment of an air or in pond water or river water, that's a solution for that. So something you are giving technology in the form of product or process that is a human creation, we can say product of human mind, that's an intellectual property. Let us see what is the background of intellectual property. Property means our minds always goes to the tangible form of property, that I am having car, gold, flat, and all. So I'm rich enough. But there is another kind of intellectual property called intangible form of property that includes intellectual property. It means intellectual property includes industrial property and copyright. Wherein industrial property again includes patents, designs, trademarks, and GI. Let us see what is the definition of intellectual property. Intangible creations of human intellect having commercial value or asset like other form of property. It means you are having a value. If you are doing something patent, it should have some value. Otherwise, many professors are taking patents from Austria for namesake. It means as soon as they file, if they may new or not, it will be registered and they're saying I'm having patent. But you should fulfill the definition of IP, that you should have a value for that IP. There are different kind of intellectual property. Patent is called as exclusive right, because once you are getting patent on your name, exclusively you can exercise the power of that right, like licensing or selling to anyone whom you want. Therefore, it also called as a negative right, because other fellow will not exercise the power of that IP. Patent is called as an territorial right, because once you are applying in the India, it's valid only in the territory of India. If you want to establish right in other countries like USA, Japan, Germany, China, or any other country, you are supposed to file your invention or your technology in those countries by means of PCT, it's called Patent Cooperation Treaty, or by means of conventional application as per section 135 of the Patent Act. It also called as a licensable right, because once you are getting patent or design and trademark, you can license to anyone whom you want and you can get royalty out of that. For example, somebody is developing a new medicine for the Parkinson's disease. So he can license to the company who is involved in the pharma for manufacture by giving the license, and he can get out of that royalty. Or somebody is developing a new washing machine. Already we are having many LG washing machine, different companies. Somebody develops that is very having some advantage over the what machines are there in the market. Then you can give license to anyone to manufacture that. Let us see what is patent then. What is the definition of patent? Exclusive monopoly privilege or right granted by the government to the patentee for 20 years from the date of filing, or priority for commercial gain in consideration of the full disclosure of his invention as a territorial right, not worldwide. It means government is giving 20 right for you when you are disclosing everything in the application. Many professors comes to us, they say, sir, I have developed some process. There are 6 steps. 2 are very important. I don't want to disclose with you. So if you are not disclosing, you will not get the patent, because as per section 10(4) of the Patent Act, you are supposed to disclose everything clearly, so that after expiry of term, anyone can use your patent and they can practice your invention. Therefore, it's must that you should fulfill the requirement of section 10(4) of the Patent Act to file a patent application. Still, many are in confusion with the discovery and invention. Discovery means finding or exploring something which is already existed. Discovery has just no technical effect. For example, we know the periodic table we have studied since science 11th and 12th. There are elements, or we can say periodic elements. Somebody is isolating new element or metal and inserting that table. That's a discovery. But process of isolation may be new, because you might have changing new temperature, pressure, or any device you might have using to do that. Therefore, that's a discovery. Another example I want to put here is that, for example, you are isolating bacteria from cement industry, because cement effluents is having many alkalophilic, acidophilic, different kind of bacteria. The process of isolation may be pH, temperature, media, what you are developing may be new, you can apply for the patent. But as such, the microorganism which is there in the nature you are isolating, there's a discovery. But genetically, if you are modifying that, that's again an invention, because genetically modified microorganisms are patentable if you are using the recombinant DNA technology. Let us see what is invention then. Any new product or process. For example, you are getting idea that I have to convert my plant product waste from my university campus into an methanol, alcohol, or any kind of an output. Or I'm finding many garbage smell, so that I should give biological treatment of my garbage waste. So these are the ideas, but you have to bring in the form of product, then definitely. Or you might have thinking I should bring a vehicle which can run on hydrogen fuel, because nowadays fuel is not available. Therefore, people are running behind the CNG gases and biodiesel. So you might have thinking, if that comes in the form of product or process, then it's useful. For example, the process of production of biodiesel. Product, a vehicle which run on hydrogen fuel. That is a mechanical device. Process, therefore, any idea should come in the form of product or process. It should be useful. Again, it should be novel than the which is in the public domain. And it should not be obvious to a person skill in the art, and it should not be in the public knowledge before the filing date. Even if you want to publish our papers, we check whether it is published in other journals or not. If it is not published, then only we go for the patent filing. It's very simple example I'm putting for the patent, that is sharpener. In the year 1822, when first time invented by C.A. Boucher, the patent has been granted to sharpener. But now term is over. Therefore, all companies are manufacturing and everyone is in the market. No one is having right for that, because when patent also only 20 years you can enjoy the right if you are also doing. After that, it will be the public domain. So he has written the claim like this: a tool. Tool means in mechanical language, device, big device. There's not word sharpener. A tool for sharpening a pencil, writing point by saving of its own surface. So this is a way of writing the patent claims, because patent is a techno-legal document. Another example of patent is electric bulb, which you and small children also know in general that who has invented this light bulb. He got patent by the scientists of electrical engineering, still not kept quiet. They are doing research and they're getting different kind of products in the market or process of electrical engineering in the market, like LED bulbs. What they are doing, they are doing improvement over the technology, what is existing there yet in short. They are not doing something, because electric energy is already invented, but we have to do improvement. So always don't think that something you have to do great thing to get a patent. If you are solving some problem, or you are doing improvement over the technology, what is existed, that is also patentable. You might have seen this telephone, and even every child is know who has invented the telephone. But there are two disadvantages you can see in old movies. One disadvantage is that if I want to talk to my friend or my colleague, someone else, 10 times I have to dial. Very disgusting. Again, I cannot change from my cabin to somebody else coming, or my house to another room, because it is having range at a particular connected point through a wire, because there only we can speak. To overcome this objection, the scientists of electronic and telecommunication engineers thought, and they came with a table phone where it is having one disadvantage, that I cannot change from my cabin to another, but I can directly dial and connect. So at least one disadvantage, we overcome that. Again, scientists of electronic thought, they came with a cordless phone, which is somewhat long. We can take in the hall, kitchen, nearby area. But we cannot take in the meeting, nor in the jail, nor outside. Therefore, we got the mobile phones that in the year 2000. So what is this improvement in the technology? What is existing in the 18th century? Therefore, all the technology has got patent. Telephone got patent, Nokia got, Samsung got, Reliance got. So all technology got patent. Therefore, you can also do any improvement over the what is technology existed. It's something you are doing great thing. No, they're solving each problem step by step. And now you are at the Andhra Pradesh. I'm here. We are talking to each other. What is this improving the technology? We are speaking to each other. So therefore, anything if you are doing new or solving any problem or making technical advancement, that is an patentable subject matter in your field. It's a recent example of 1994. Till this, we are not having any data to transfer any tool to transfer the data. Therefore, now you are saying I'm having Bluetooth in my mobile. I can transfer pictures, data, and movies. So what is this? This was invented by Geoff Hudson. These are again different example of the car, nano car, this medicine, this limb. These are all in patent examples. So different you can do. Again, this all drone and all development, many different scientists. So these are all examples of different patents. Most common by the mistakes made by the inventors, especially by the teaching faculty. They always run for the publication, the international of this journal. No one is asking now how many publications you are having. They ask how many patents you have filed. Among those, how many of them have been granted? Not even at least only 5, because filing is easy, but getting grant is, and it should be novel inventory. Then only you are getting the grant for that. So always file the patent, then go for the publication. By knowingly or unknowingly, if you are disclosing in the conferences, then within 1 year from that disclosure, you can file the patent application. If you are using your invention in the public, please maintain the secrecy. Otherwise, somebody will copy and they will file before you in the patent office. If you are not sure that what research you are carrying out is having value or not, then wait till whole lab are complete. Let prototype ready, then you can go for the patent filing. Let us see another kind of intellectual property called designs. Design means shape, configuration, pattern, or ornament, or composition of lines or color combination thereof applied to any article in the form of 2D, 3D, or both the forms. Design is applicable to the eyes and beautiful end product. I have shown you Bajaj iron box. You can check different company iron box. The design is different. This cup set is very beautiful. That's a design. How it looks, it's called design. Khitan fan design is different from Bajaj fan. My kettle, heating kettle is Skyline. This design is different from other kettles. You can check. My cup design is also different. My Pounds powder, whatever I'm getting, that is also design is different. Again, if you check the HP laser printer is different from other printers. Sony TV is different from Samsung TV. These are all designs, mere functional and technical feature arises in the patent, but not in the designs. Designs is only by looking to the eye, it should look beautiful. Sofa set design, spoon design, chair design, freeze design, any kind of design. If you're developing, you can go for the registration. Term is 10 years. You can extend for 5 more years, total 15 years term. You can enjoy with the designs and you can license it, get the royalty out of that. The sanitizing machine now we are using in every campus for sanitize our hands. This also registered designs. You can check different products which are already registered are ampoules, capsules, thermometers, what we are using to measure our temperature while entering the campuses. You can check textile designs, jewelry designs. You can check Timex watch is different from Titan watch because each design is registered by their particular company. These are the bottle different. See, all are bottle, but they are having different designs. The shape, configuration, surface pattern of the bottles are different. Therefore, these are called designs they got registered. We can check design of toys, school bus, biscuit, pencil. All designs also got registered. Pen. Let us see another kind of intellectual property called trademark or trade name. Visual symbol, which may be word, name, brand, numerical, or combination of colors to indicate the source of the goods. So it gives the authenticity of the goods, what exactly they are. Reliance, it's a good product. PS, Amazon, Tata, but all these called as the brands which have got value for that. It advertises goods and services, protect the innocent public from buying the goods of second-rate quality. मी करतो lecture मध्ये protects the innocent public from buying the goods of second-rate quality. R with encircle design, registered trademark. TM means trademarks applied for. It means Once you're applying, it's go for examination, publication, opposition, if any, then further registration. Therefore, many bottles, many medicines, many products you might have seen, TM, some written R with encircle. It means registered trademark, and when it's applied, you have to get the registration. Duration is 10 years, can be renewed every 10 years it use, because Tata, Bata, how long they are in the market, they are renewing their mark. There are different trademarks, trade names also there, collective marks are there, certification marks are there, taglines are there, slogans are there, shapes. These are all got trademark. Google, Naukri.com, Edil Mange More, Bureau of Indian Standards, all these are trademarks. Distinct trademarks are there. TM and R is written. Now, let us see what is geographical indication. Place names used to identify source of origin, quality, reputation, or other categories of products like Darjeeling tea, Kanchipuram silk sari, Kolhapuri chappal, Agra peda, Nagpur oranges, Solapuri terry towel, Kolar gold mines, Arabian petrol, saffron of Kashmir, Rasgulla of Odia and Bengal, all these got GI. Darjeeling tea example, marble of Rajasthan, Kanchipuram silk sari, Patlami seo. So these are called GI. Warling painting, Bidri ware, Kashmiri saffron, Sahi lychee of Bihar, Kurg orange, GRST for this also. So mangoes all got registered. Let us see another kind of intellectual property called copyright. Provided holder the right to restrict unauthorized copying and reproduction of an original expression, literary work, movie, music, painting, or software. Any software if you are developing, it comes under the copyright. Software with the combination with the hardware is like ATM machine, mobile, or patentable subject matter like X-ray machine, CT scan machine. The life of the author plus 60. You might have seen many books were written by the authors. They are no more, but still they are getting the royalty for that. Many singers no more, but still they are getting royalty for that. The copyright is called as a bundle of rights. It should require creativity, originality, and fiction creation criteria of the work to be copyrighted. Literary work, artistic like design like this, dramatic like this, drama, musical works, anything, sound recording, cinematic film, all this will comes under the copyright and you can go for protection of that. Let us see how this single product can be protected by the different IPR. It means you are also developing some new device or process. So how you can get protection for that? What is the importance also? Sony TV in the year 2000 or in and around that, very famous for clarity and sound. Therefore, they got patent technology, patent that is called remote control mechanism, an invention. It is a technology, so got patent. How it looks beautiful, it's looking. Therefore, they got the design registration. The name Sony as such, they got the trademark. The instruction or manual can be copied. Means what is the instruction how to use that is copied. So single product, if you are also bringing product different IP, therefore other company will not copy neither technology nor patent, trademark, nor design, nor copyright. Like Samsung TV company is also manufacturing TV, but they are not copying the Sony technology because if they are copying, they'll sue in the court and they have to pay the damages to them. Therefore, each company is protecting the technology with different intellectual property so that no one will copy their technology, nor design, nor mark. Let us see what is trade secret. Trade secret is a technology which is maintained secretly, never been disclosed nor published anywhere else. That is called trade secret. For example, I have taken this example of Domino's Pizza because everyone might be tasted Domino's Pizza and they are very to visit that, especially students who are listening. So the taste of Domino Pizza is different from the taste what you are getting the pizza in other hotels because they're adding some trade secrets that is disclosed to the people who work in the kitchen of that Domino's. You might have seen Hyderabad biryani taste is different from other biryanis because they're adding some taste ingredients. Mysore dosa, we are getting across Andhra, Karnataka, Maharashtra also some Udupi hotels, but the taste what you are getting in the Mysore area of that Mysore dosa is different from other because of they're adding some trade secret which is not disclosed to anyone else. They maintain secretly. The formula of Coca-Cola, the formula of Mazda, we don't know. It's called trade secret. This is you can check different mobiles you might be having in the hand. That maybe somebody's having Apple, Samsung, Reliance, Vivo, and all. So all the designs are different, and each company got registered. Each technology, the combination of hardware and software got patent, and the instruction of that got copyright, and each mark, Nokia, Samsung, Reliance also got trademark. So any product, if you are being engineers developing, then you can get protection so that no one will copy that. What can do with the IPR? This is for students. Why we have to study the IPR? Why government is making compulsory one subject and one paper on the IPR? Because if you are a science graduate, it means any BSc, BCA or BE, you can become a patent agent every year, or office call for the examination of patent agents. Then you have to, again, two papers there. One is objective, another descriptive. If you write and qualify, definitely get a patent agent number from Government of India. And you can practice that. If you're a plain graduate or a law graduate, you can become trademark agent or copyright law agent. If you're having knowledge of patent or IPR, you can work in the IPR policy or IPR cell of the central government, state government, companies, colleges, and schools. And you can help to everyone. You can work in the NGOs or different IPR firms in different cities. You can join to the IPR firms. Or if you are a MS in chemistry, biotechnology, microbiology, or any branch of B, can join to the government office by writing the exams. Again, two papers, one is objective, another descriptive. If you qualify, you'll get a job in the Government of India. You can do what means you can also become a scientist, or faculty can also be inventor, but they are not doing. If you want to do a project, or if you are carrying out a research, identify some problem in your own field, solve that problem, you can apply for the patent. For example, you are a mechanical engineer. You can check whether there is knob which indicate the pressure for the gas cylinder is available or not. Then you can invent for that. If it is available, don't go do something else. Otherwise, go. Or a device which can, you are a filter which can filtrate the pollutant air, and you can get good filter for our nose or somewhere else. If you are a electronic and telecommunication engineer, you can do some more invention in the software area. If you are a civil engineer, the process of production of cement with different gypsum concentration you can prepare. Or device which can convert sugar molasses into alcohol, mechanical can put. So depend upon you, you can develop and solve that problem. If you're a microbiologist, develop a biological treatment of pond water or river water. Or if you're a mechanical development of a device which convert direct wind energy into some other form of energy. So all these are the energy inventions which you can see in and out. One of the Nagpur fellow who is studying the 8th standard has invented a device which give indication that you are getting a heart attack because he has developed that. So many things have been developed in the electronic and telecommunication software. Now also there are still many more areas of research you can do in new research by taking the help of Google. But if you want to do a project, you are going to the library, copying the senior thesis and changing the data and submitting to get a degree. It's not a research. If you are doing really research, you will get 1 or 2 patents on your projects or your thesis. What can be patented in India? In India, all the products and processes are patentable, but method of treatment, plant as such, animal such are not patentable. Devices, chemical products are patentable. When we can say that your technology is new, when it should not be published anywhere else, not only in India, throughout the world. It should not be in the prior public knowledge in India or use claimed before in any specification in India or else, means it should not have been filed in any other application. Then the work what you have done, the technology what you have developed, or the project what you have carried out is new. How we can say that your technology is fulfilling the requirement of invention? It should be technologically advancement and it should be economic scene. For example, as I told you, telephone which Alexander Graham was invented, now mobile phone. This is a technical advancement. Therefore, they got the patent for different company. Economic, Earlier, mobiles were very costly when in the year 2000. Now, very cheap. That's an economic significance, or both. And it should not look obvious to you. Means you cannot feel that easily I can do this. You should require some experimental skill. Then it is not obvious to a person's skill in that. Then you are fulfilling the requirement of inventorship. Like some surprising result you should get. Solution to a long-standing problem. Since long back, we needed a device to convert solar into electrical, but we not got. Now we are getting solar panels and all. Fulfilled of a long field. We are using gas cylinders in the home. Since long back, we required knob to indicate the pressure, how much remaining, but still not got. That's a long field need. Great technical process. That is coaxium, covalent. Within 2 years, we got. That is a great technical process. It should be useful to anyone, as I told you. Writing the application, your application contains, like our project contains something, like MPhil thesis contains something, PhD thesis contains some pro forma, same way, it should have title and preamble. Object of the invention, how it is, then drawbacks, what are those we should know, what solution you are putting, you have to give, detailed summary, drawings, examples, then you have to claim what you want protection for that. These are the content of the application during submission of the patent application. There are different claims. One is called independent claims, another is independent. Independent means process of making herbal tea comprising steps of is an independent claim. The process as claimant wherein 1 cup of water taken, again adding milk, pinch of powder, then for taste ginger. All these are dependent claims. Here also process as claim on like this. One example is I have taken as a foldable pen as you are a teaching institute. Foldable pen, why they came to foldable, what is their objective, what is decided, so they are doing it. So as I shown you, these are drawings of this. You have to prepare drawing in this fashion. This form to readily available, you have to fill it. Then main object of the invention. What is object? He want to give a foldable pen to everyone. Background what? How the earlier pen, which are their hexagonal, barrel, circular, cross-sectional, how they are bad, therefore he is getting new idea to make the pen. So all the disadvantages he is mentioning. Again, he is giving what exactly his new pen advantage having. That we have to give again. 1 or 2 pages. Then what is the exact statement of invention? What exactly you are doing? That you have to give 1 or 2 pen again. Then you can give brief description of drawings. Figure 1, what is that? Figure 2, what is that? Figure 3, all more than that figure also. You can explain what those figures are. In detailed description, how these all figures are coming together, joining to work as a pen. Therefore, you have to disclose each figure 1, 2, 3, how they are connecting with each other and working as a pen. If you are claiming as a washing machine, how all the circuit is acting together to work as a fridge or washing machine, you have to explain in 2 page, 3 page, 5 page, more than that, how you are able to do. Lastly, you have to claim what you want protection for. That is, I claim is a single applicant. We claim is more than. He is claiming foldable pen comprising flat body of so and so shape, having hinges so and so, no full stop. He's using semicolon. Hollow reservoir, it's having located at one of the panel for storing and dispensing the ink again, and writing tip extending to the reservoir. Then dispensing the ink is a full stop, means pen is completed. Now other features are a foldable pen as claimant, wherein it is a same size, not thick thin, it's a throughout same size. Foldable pen panel is beveled. It is a truncated pyramid form. It's having hollow reservoir. It is a ballpoint pen. So he is telling all the feature of pen in other claims that is called preferred embodiments or preferred features, or you can say additional features over the main claim. So lastly, sign and signature is must. Now, how to file the patent application in India? Who can file? Any person can file the patent application. There is no age bar limit. MSME, startup, anyone can file the patent application as per Section 6 of the Patent Act. You can file physically by going to the office, or you can file online as we have given facility since July 20, 2007. We are having jurisdiction as you are from South, so your jurisdiction is Chennai. Chennai covers the state of Andhra Pradesh, Karnataka, Kerala, Tamil Nadu, Union Territories of Pondicherry, and Dakshita, newly formed state Telangana. Covering letters, documents required for that. Covering letter indicating the gist of the documents. Form 1 is a must that neatly you have to file in that column 9. you are supposed to fill to declare the inventorship. Form 2 is required whether you are filing provisional or complete. Provisional means as soon as idea comes to your mind, you are filing or writing piece of paper, that's a provisional application. Complete means once you are completing all the research work, then you are filing. There is a complete application. If you are filing Form 3, that you are mentioning that how many countries you are filed, that you are mentioning in this application. Form 5 is to declare inventorship. It means in paper publication, how you are adding your friend's name as a first author, second author, or third, same way. You can add your friend's name, so directly or indirectly help you to file the invention. So, but there are not having equal rights, but in patents, all the inventors are having equal rights. So please keep in mind and then write their names. Form 18 is required for the request for examination. If you are not requesting, we are not examining your application. Fees in the form of DD or check if you are filing physically. If you are filing online, you can pay online. Fees is 1,600 for natural person and 8,000 for the company, up to 30 pages. More than that, each page 160 for individual, 800 for company. More than 10 claims, 320 for individual, 1,600 for the company. And for all the teaching institution, 80% fee concession. So because all the teaching institution should have filed more inventions as China is filing. In India, we are very far in filing the patent, design, trademark. So you being the teaching institute, you should do good new projects which are innovative and file more and more patent with the help of your professor or guides. For the request of examination, 4,000 for individual, 20,000 for other than that. Fees may be always changing. During the filing, you have to check website, then you can go for the filing of the patent application. If you want to express early publication, then you can request by Form 9, you have to pay the prescribed fees. If you want within 1 year or very early patent, then you can file an expedite examination as per Rule 24B. While choosing India as an international searching authority or international preliminary exam authority, you can file, or applicant is in startup. As per 2019 rule, one of the applicant can be ladies or government organization and institute can also file the patent application. Fees is 8,000 for individual, 60,000 for the company. You can get forms on www.ipindia.nic.in. If you want to file online, ipindiaonline.gov.in. This is a procedure to grant the patent. Once you are filing the application, let's go for the digitization. Then we are doing screening and classification. We are using classification, international patent classification to classify the patent, depend upon the field like electronics, mechanical, civil, electrical, biotechnology, microbiology, or pharma. So that international patent classification help us to automatic allotment to the patent application. As we are having different specialty examiners, like some are expert in mechanical, civil, electrical, some are expert in biotechnology, microbiology. So depend upon the expert, it has to go to the particular application. And we are not allotting physically. We are having auto allotment system. Therefore, screening and classification must. If you are requesting for early publication, we publish within 1 week or at maximum of 1 month. Otherwise, we publish after 18 months only. If you are requesting within 48 months from the date of priority, date of application, it's go for the allotment of the application. Once it published, anyone can file the opposition, that is called pre-grant opposition. Once it allotted to the examiner carry out the search, study the formal and technical requirement, then he make the gist of the objection and forward to the controller. Controller again recheck, and he can add, delete the objection. He prepared the final report, that is called first examination report, and forward to the applicant or applicant agent. During that, he will take the record of pre-grant opposition also. Once applicant is able to overcome all the objection, it will go for the granted. If applicant fails to overcome all the objection, it will be rejected. If you are granting or rejecting, we give the speaking orders, they can appeal to the High Court and other courts. Once it is granted, we publish the grant of the patent application. Then within 1 year from the date of publication, any interested person can file the opposition. Now, who is the interested person? For example, Maruti Suzuki has invented a new engine. So Hyundai company, Tata Motors, or any other motor producing company can file the opposition, that is called post-grant opposition. Then the grounds what you've taken in the post grant are forward to the applicant. Applicant give replies on each ground to the opponent. And opponent again reply to the applicant. If any one of them is requesting for the hearing, we keep the hearing. Simultaneously, we constitute that opposition board inside the office. There are 3 members, one is chairman, 2 are the members of the board. They give the recommendation on the opposition. Then during the hearing across the table, like a court hearing, we call the applicant, opponent, and others for the hearing, and we discuss each ground of the opposition. If applicant is able to overcome or answerable to each ground, then it will be patentable. Otherwise, it will be rejected. Then, if granted same day, we issue the certificates. What is the role of intellectual property? Encouragement for the improvement of technology, providing reward as an exclusive right for disclosure, making profit for earning royalty through putting the invention to practice, transferring it to public property after expiry of term. Don't take patent for the namesake, let it practice and earn from that. Now you came to know what are intellectual property rights, their roles, their importance, how to file, how to write also. Now don't keep quiet. Save the benefit of patent system to the schools, colleges, universities, and wherever you get opportunity in the society also. Utilize the resource through organized R&D activities, capture the global market judicially, earn profit through the protected market. Thank you. You can ask any doubts.
Thank you very much, sir. Now I am asking to all the participants, if you have any doubt, please ask and share with our resource person, sir.
I would like to ask one question, sir.
Yes, ma'am. Most welcome.
If suppose my work is related to modeling, can we patent it?
What kind of modeling can you just briefly tell me?
Any analytical modeling?
And with electrical?
Yes, analytical modeling.
Okay, model. Steps of that model are product as such.
So like, if suppose I want to the characteristics of the MOSFET, latest advanced MOSFET. So some mathematical equations are there.
Yeah. So mathematical formulae are as such not patentable as per the patent act, or method of presentation also not patentable. It's a copyright matter.
Okay, sir.
Any other question?
Thank you, sir.
Any questions, even simple doubts, you can ask me. No need to hesitate for any doubts, because some are newly to the IPR session. Somebody is raising hands, please. If you are unable to ask, put in the chat box. Madam will read that objection, then I'll answer.
Those who want to ask the question, they can unmute yourself.
Now, okay. Hello. Hello, good morning, sir. Hello.
Sir, you continue. Your voice is audible, sir.
Yeah, I am Dr. Basaraj from IIC department, Siddhartha. Regarding suppose for example, some mathematical functions, we do our own method from different methods, different graphical method. Could you go for that patent, sir?
No, sir. Mathematical method is for the copyright only, not for the patent.
Okay, sir. Different methods, sir. Methods are some.
No. All method also no. BC, as I told you, to patent, it should be product or a process.
Okay, sir. Okay, thank you, sir.
Any more?
I request all the participants to feel free to ask the questions. This is the golden opportunity. We can.
Yes, dear students, you can also ask because professor already got the job. They are well settled. So student had to fight to do new work and get a patent. So you can ask because you can, with the help of professor, you can do new patents, new designs you can do.
Okay, no queries are there. So I request Gangaya Yadav sir to wind up the session.
Yes, ma'am.
Thank you very much, sir, for your valuable information sharing with us.
Thank you, sir.
Yes, sir. Thank you very much, sir. Any event cannot be success without involvement of group of people. In order to thanks to everyone, now I would like to thanks to Chairman Sir, Siddhartha Group of Institutions, Dr. Ashok Raju Konduru Garu, to providing facility for conducting this program. And I would like to thanks to Principal Siddhartha Institute of Science and Technology, Dr. M. Janardhan Raju Garu, for making free hand to us conducting this program. And I would like to thanks today resource person, Dr. Bharat N. Suryavamsi Garu, for sharing your valuable information with us, sir. Thank you very much, sir. So today we learned so many things about IP Act, sir, because so many people having so many doubts how to file the patent. Okay, so thank you very much, sir. I extend my heartfelt thank to all the participants for participation and time spending in this knowledge sharing platform. Thank you very much to all. Last but not least, my heartfelt thanks to all the faculty members of ECE Department, Siddhartha Institute of Science and Technology, for their effort making this program grand success. And also I want to thank, special thanks to Dr. Savitesh Madhulika Sharma sir. She is the convener of this program for making this program grand success. So she has put more effort for making grand success of this program. Thank you very much, ma'am. Savitesh, ma'am.
Thank you, sir.
Now I'm sharing the feedback link in the WhatsApp chat box. All of you, please fill the feedback form. Who fill the feedback form, those only can get the certificate. Thank you very much, ma'am. Thanks to all.
I leave the platform. Can I leave?
I request everyone to fill the feedback form so that you can get the certificate. And whatever be the details you are writing, write in capital letters. So if you have any query regarding the feedback form, you can ask, then we will close the session. So thank you, everyone. We are going to close this session.